Welcome back for another human resource lecture. As you know, if you've been following my channel, hopefully you've subscribed. We are in the course of employment law, which is vital and very important in human resources because it obviously lays out the laws that govern the workplace and the work environment. So today in employment law, we are talking about alternative dispute resolution. This is chapter 6. This is an important chapter because a lot of problems arise when people are working with people, which is what human resources is, managing people. A lot of problems arise, and what used to happen through litigation in court, which was expensive and time consuming, actually has been replaced chiefly by arbitration and mediation, two types of alternative dispute resolution that we will actually discuss. Okay. Arbitration was designed as an alternative to litigation because it is generally less expensive and less time consuming. It stays in-house, it gives both parties, the employer and the complainant, an opportunity to kind of hash out their differences, see if they can come to a resolution. So that's important, and a lot of companies prefer and have new employees sign a type of arbitration agreement. My employer actually has arbitration as its form of alternative dispute resolution. All right. Okay, so we're going to continue on. With arbitration, you have an arbitrator. An arbitrator examines documents, listens to testimony, and then grants an award on factual determination. I'm not talking about the arbitrator from Halo. That's my joke. Okay. The award that an arbitrator grants or decides on is binding. A court, however, may overturn an arbitrator's award if they find out that the arbitrator was biased, acted improperly, or something wrong. Other than that, there can be no problem shown. What the arbitrator decides actually stands. The next part of arbitration would be the Federal Arbitration Act, or the FAA of 1925. So a lot of people are probably going to ask why I'm not using this nice large whiteboard here that's pictured. And it's actually because I forgot to grab dry erase markers before I reserved this room. And by the time I got back out there, they were out. So I said, we're going to keep it old school. And I went to the trunk, grabbed this, and said, let's get back to it. Okay? So we're going to continue with our ADR. Hopefully this is standing straight, so my video shows it well. Okay, the FAA. The purpose of the FAA was to raise the credibility of arbitration agreements by providing for court enforcement. Okay? An employer should raise concerns over fee splitting arrangements if the employee believes it will present financial burden. Okay? So the FAA's purpose was to solidify arbitration. A lot of employers saw this, like I mentioned before, saw the benefit in arbitration and mediation, and law was drafted to, or I should say an act was drafted to kind of help enforce this. There are fee splitting concerns that do come up. Occasionally employees feel that they can't afford the costs related to arbitration. And in these type of situations, both parties need to discuss the financial endeavors around it. Okay? Okay. The last two topics we're going to cover in our ADR are mediation and a mediator. So mediation is a voluntary method that can be used to resolve disputes by having the parties reach a solution. Okay? A mediator is an experienced individual in dispute resolution who attempts to aid parties in finding common ground. So the purpose of these individuals is that they're placed, usually they try to find somebody that has no relation to either parties, that can listen in or hear the case and come to a unbiased, non-discriminatory, non-influenced decision in fairness. Basically, they would kind of they would almost oversee, both parties would oversee, similar to how a judge listens to both sides or magistrate and makes a decision. Okay? So that's a general overview of the main points and topics in ADR Chapter 6. So if you're following along in your employment law course, I have sectioned out or picked the larger chunks or components from the chapter that will be showing up on the tests and exams and that your professors are going to be asking you about. All right, any questions, please leave them in the comments. Reach out to me. I want to learn and communicate with you, grow with you, and please subscribe to my channel. Remember, anything that I mention is always just information. None of it's legal advice. For any legal problems you have, any challenges at work, please always speak to an employment attorney or a professor of law.